The hearing today, which is entitled Too Big to Prosecute, Examining the AI Industry's Mass Ingestion of Copyrighted Works for AI Training. This is the third hearing of the Senate Judiciary Committee's Subcommittee on Crime and Counterterrorism, which I'm delighted to work on with my colleague, Ranking Member Durbin. I want to thank you, say a special thank you to the witnesses for being here. Many of you, I think all of you, traveled in order to be here today. Thanks to everybody for accommodating our change in time. The Senate floor is going to be tied up here later today, and thus no committee business is happening. So thanks all of you for being here and for accommodating us. I'm going to make just a few opening remarks. Senator Durbin will do the same, then we'll swear in the witnesses and be off to the races. Let me just start by saying that today's hearing is about the largest intellectual property theft in American history. For all of the talk about artificial intelligence and innovation and the future that comes out of Silicon Valley, here's the truth that nobody wants to admit. AI companies are training their models on stolen material, period. That is just the fact of the matter. And we're not talking about these companies simply scouring the internet for what's publicly available. We're talking about piracy. We're talking about theft. For years, AI companies have stolen massive amounts of copyrighted material from illegal online repositories. Now, the FBI and the Department of Homeland Security regularly prosecute individuals who engage in exactly the same kind of behavior, using platforms like LimeWire or Napster in the old days, using a process called torrenting. But have these big tech companies been prosecuted? No, of course not. They're getting off scot-free, and this hearing will show us that Meta and Anthropic and other AI companies are willfully using these illegal networks, these torrenting networks as they're called, to steal vast swaths of copyrighted materials. The amount of material that we're talking about is absolutely mind-boggling. We're talking about every book and every academic article ever written. Let me say that again. Every book and every article ever written. Billions of pages of copyrighted works, enough to fill 22 libraries the size of the Library of Congress. Think about that. 22 libraries of Congresses full of works. That is how much has been stolen, and this theft was not some innocent mistake. They knew exactly what they were doing. They pirated these materials willfully. As the idea of pirating copyrighted works percolated through Meta, to take one example, employee after employee warned management that what they were doing was illegal. One Meta employee told management that, and I quote now, "This is not trivial," and he shared an article asking, what is the probability of getting arrested for using torrents, illegal downloads, in the United States? Another Meta employee shared a different article saying that downloading from illegal repositories would open Meta up to legal ramifications. That's a nice way of saying that what they were doing was exactly, totally, 100% barred by copyright law. Did Meta management listen? No. They bulldozed straight ahead. We'll see evidence today that Mark Zuckerberg himself approved the decision to use these pirated materials. And then, the best part, Meta management tried to hide it. They tried to hide the fact that they were engaged in the illegal download of pirated works. And not just the illegal download, but the illegal distribution of these same works. They tried to hide it by using non-company servers. They went so far as to train their AI model. Get this. Meta trained its AI model to lie to users about what data it had been trained on. I mean, you talk about an Inception-level worthy deception, training the AI model to lie about what its own sources were. This isn't just aggressive business tactics. This is criminal conduct. And I just want to point out, Meta's conduct is not an exception. This is the rule when it comes to what is happening right now in the AI space among these mega companies. Big tech operates on the model of do whatever you want and count on the lobbyists and the lawyers to fix it later. They don't care about the rule of law. They don't care about America. They don't care about freedom. They certainly don't care about working people. They care about power, and they care about money. And every time they say things like, we can't let China beat us, let me just translate that for you. Every time they say that, we can't let China beat us, what they're really saying is, give us truckloads of cash and let us steal everything from you and make billions of dollars on it. That's the translation. And we're going to see that in the testimony and the evidence today. Here's the bottom line. We have got to do something to protect the people of this country. I'm all for innovation, but not at the price of illegality. I'm all for innovation, but not at the price of destroying the intellectual property of the average man and woman in this country. We have laws for a reason. Those laws ought to be enforced, and big tech should not be above the law. Enough is enough. It's time to enforce the law, and that's what this hearing today is about. Now I'll turn it over to Ranking Member Durbin.
Thanks, Mr. Chairman. The way AI interacts with intellectual property rights, particularly copyrights, is a critical topic we can't overlook. America's creative industries, including software, music, movies, literature, collectively contribute over $1 trillion to our economy each year, employing millions of people. While AI can be an incredible tool that unlocks further creativity, writers, artists, musicians, and others are rightfully concerned about what technology means to them personally. Should AI companies be able to use their materials freely as, quote, fair use, unquote, or should they receive compensation when their works are used to train AI models? I want to tell you, Chapter 1, how I discovered intellectual property. I was an attorney in Springfield, Illinois, and in a rash moment decided to buy a restaurant. So I joined a few friends and bought a restaurant, and we had live music. And I got a phone call one day from a fellow who said, I just was out at your restaurant. I said, great, did you have a good time? Couldn't have been better. Saturday night, the music was terrific. And I said, well, I'm glad you had a good time. And he said, you played 10 BMI tunes and 6 ASCAP tunes. I said, no, I didn't. I didn't play any tunes. He said, well, the way the law is written, you're responsible for the fact that copyright material was used by you to make a profit at your restaurant. I said, tell it to the judge. He said, no, wait, before you say that, call your friend over in Jacksonville, Illinois, a few miles away, and ask him about a similar experience, and his reaction was the same as yours. I called my friend who said, ask him how much money he needs each month for ASCAP and BMI, and we started paying it. That was my first course in intellectual property. I hold on to it to this day. So how can creators compete with AI products that generate content at the push of the button, especially when the content might mimic or even produce their own work? These are just a few of the questions that we're going to consider in this hearing as we try to find the right balance between promoting technological innovation, protecting the work of our nation's creators, and continuing to incentivize creativity in years to come. We must recognize that AI innovation and protection of intellectual property rights are not mutually exclusive. That's why it's troubling, as I listen carefully to the chairman, to hear stories about steps big tech companies are taking to train their AI models on copyright materials without compensation to the creators of these works. For example, rather than license authors' works, companies like Meta and Anthropic have obtained copyright materials from sites that host pirated copies of the author's books and writings. Anthropic pirated over 7 million books from shadow libraries. As Anthropic's CEO put it, Anthropic had many places from which it could have purchased, but it preferred to steal them to avoid, quote, legal practice business slog, whatever that means. While Anthropic later became not so gung-ho about training their LLM on pirated books for legal reasons, it kept the pirated copies that it had already downloaded anyway. I don't get that. As a judge in the Meta case recently put it, quote, companies have been unable to resist the temptation to feed copyright-protected materials into their models without getting permission from the copyright holders or paying them for the right to use their works for this purpose. This hearing is going to be interesting. Thanks, Mr. Chairman.
Thank you very much to the ranking member. It's the practice of the Judiciary Committee and all of its subcommittees to swear in witnesses before they testify. So could I ask you to stand up, raise your right hand, and repeat after me? Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Very good. We'll now proceed to opening statements. We'll give 5 minutes to each witness. I'll just say a brief word of introduction before each witness. We'll just go straight down the table here, down the dais. We'll start with Mr. Max Pritt. Mr. Pritt is a partner at Boies Schiller, and he represents authors in a civil copyright infringement suit against Meta, among other matters. Mr. Pritt, the floor is yours.
Chairman Hawley, Ranking Member Durbin, thank you for the invitation and opportunity to testify today. The Art of the Deal by Donald Trump, Hillbilly Elegy by J.D. Vance, Theodore Roosevelt, Preacher of Righteousness by Josh Hawley. These are just a handful of the many, many millions of copyrighted books and publications that some of the world's largest and wealthiest corporations, Meta, OpenAI, Anthropic, and others, knowingly and intentionally pirated from illicit online marketplaces for financial gain and to seek a competitive advantage in AI. Today, this committee begins to investigate and shine a light on what is likely the largest infringement of American intellectual property by US companies in our nation's history. As tech companies scrambled to release generative AI models and to catch up with OpenAI's ChatGPT, many of them turned to illicit online repositories to take tens of millions, if not hundreds of millions, of books and scholarly publications and articles for free instead of buying them or licensing them from copyright owners. By pirating these works, AI companies have built a multi-billion-dollar industry that is projected to be a trillion-dollar industry in the next few years without paying a single cent to the authors whose works power their products or the publishers responsible for introducing those works to the public here and abroad. Take Meta, for example. From the early days of its generative AI program, Meta concluded that training its models using books and articles would help their performance. But instead of buying or licensing these works from copyright owners, Meta decided to take them from notorious online marketplaces of stolen copyrighted works, including some of the same ones targeted by the Department of Justice and the FBI for criminal copyright infringement. And Meta didn't just download books from these illegal repositories. It used the same kind of peer-to-peer file sharing networks that powered Napster. In other words, Meta also made copies and sent them to other pirates. In total, Meta pirated well over 200 terabytes of pirated books and articles, a size comparable to the entire printed collection of the Library of Congress 20 times over, or the equivalent of a stack of many billions of pages of text. Meta's piracy included many millions of works, including at least 12 books authored by members of this very subcommittee and every US president and vice president in the 21st century. Meta also made and sent copies of over 40 terabytes of pirated works to others. In doing so, Meta has helped to revive online piracy by propping up the foreign criminal syndicates that run these illicit marketplaces to violate US copyrights around the globe. As Anna's Archive, the largest illicit online marketplace of stolen literature in the world today, says on its own website, shadow libraries were dying, then came AI. Meta is not alone, and it was not the first US company to engage in rampant domestic piracy for its own commercial purposes. Pending lawsuits against OpenAI and Anthropic revealed that both companies also pirated millions of copyrighted works. And the decisions to engage in this mass domestic piracy were made at the highest levels. Company documents that are now public show, for example, that the decision to pirate instead of license was approved by Meta's co-founder and CEO, Mark Zuckerberg himself. This decision to engage in mass piracy was made even though key employees knew that doing so was both illegal and unethical. One Meta researcher argued that using pirated material should be beyond our ethical threshold. Another called Meta an accomplice to piracy. Yet another warned that if the media got wind of the company's use of pirated data, it could undermine Meta's negotiating position with regulators. The very people in this room and across the hall, in the White House, and in state houses across the country. And when asked if he cared whether Meta protects human creativity rather than exploits it, Meta's head of AI partnerships testified he does not care. AI companies now seek a pass for this unprecedented piracy by invoking a limited exception to copyright infringement called fair use, which Congress codified in the Copyright Act of 1976. They also argue they can't compete with China if they can't infringe every American's copyright. Nonsense. Our tech companies employ the best and brightest minds in the world, and they are the wealthiest corporations in the world. It is not credible for these companies to argue they can invest hundreds of billions of dollars into hiring talent and building data centers to power their commercial AI products and models, but they can't pay a single cent to copyright owners. There is no carve-out in the Copyright Act for AI companies to engage in mass digital piracy. I'm grateful to Chairman Hawley, Ranking Member Durbin, and this subcommittee for your attention to the issue. I look forward to your questions.
Thank you very much. Next up is Professor Mike Smith. Professor Smith is Professor of Information Technology and Marketing at Carnegie Mellon University. He's written extensively on piracy and its effects on innovation. Professor Smith.
Chairman Hawley, Ranking Member Durbin, I am very honored and thankful for the opportunity to testify today on this important issue. My testimony today is informed by 25 years of empirical research into the impact of new technologies on the markets, on the creative markets, and my experience serving on a roundtable of 10 economists convened by the U.S. Copyright Office to study the implications of generative AI on copyright policy. My research into piracy started in the early 2000s when digital piracy was a relatively new problem for the creative industries. During that period, many in the tech community argued that piracy was fair use because it would not harm legal sales, was unlikely to harm creativity, and any legislative efforts to curtail piracy would not only be ineffective, but would also stifle innovation. My empirical research over the past 25 years has studied these questions. In 2020, my colleagues and I surveyed over 40 papers published in peer-reviewed academic journals as part of a piracy landscape study we wrote for the U.S. Patent and Trademark Office. Our report drew 3 broad conclusions. First, the peer-reviewed academic literature shows that digital piracy does harm creators by reducing their ability to make money from their creative efforts. Second, the peer-reviewed academic literature shows that digital piracy does harm society by reducing the economic incentives for investment in creative output. Third, the peer-reviewed academic literature shows that copyright enforcement has been effective in reversing these harms, while also allowing businesses and legal online distribution platforms to thrive and innovate. Today, we're hearing many of the same arguments we heard in the early days of the internet. Allowing generative AI companies to use pirated content to train their models is fair use because it won't harm legal sales, won't harm creativity, and any enforcement efforts to curtail the use of pirated material for training will not only be ineffective, but will also stifle innovation. My response to those arguments is that while the time has changed, the underlying economic principles are the same today as they were in 2000. And by applying those principles, I think we can draw many of the same conclusions. First, the use of pirated content to train generative AI models will harm sales for creators. Allowing generative AI companies to train their models with pirated content is likely to harm markets for creators by damaging the original markets for their work, by damaging licensing markets for those works, and by creating perverse incentives for bad actors to add new copyrighted content to pirate networks, in essence, allowing generative AI companies to launder licensable content through piracy. Second, the use of pirated content to train generative AI models will harm society by reducing economic incentives for creators. This conclusion is similar to the early piracy research. Economic incentives drive creative output. But there's a new and unique indignity to our current situation. When piracy is used to train generative AI models, we're not only stealing from creators, we're then using the theft of their content to create tools that can flood the market with machine-generated output, which in turn will replace many of those creators, particularly emerging artists. And third, as in the early days of piracy, I believe that enforcing copyright law in the context of generative AI training can be effective at reversing these harms, and can create a world where both the creative industries and the technology industries are able to thrive. If the Napster and Grokster decisions had gone the other way in the early 2000s, it's hard to imagine that Spotify and Netflix would exist today, and that would be to the detriment of consumers, the creative community, and the technology community. I think today we have a similar opportunity to create a win-win-win for society, creators, and tech firms by making it clear that piracy is wrong and that a vibrant technology economy depends on a vibrant creative economy. We found a way to make licensed streaming and sales channels work for consumers, copyright owners, and platforms in the early 2000s. We must do the same for generative AI today. Generative AI has the potential to benefit industry and society in many ways, but achieving that potential will require a more robust and transparent partnership between technology firms and the creative industries. On our current path, we risk killing the goose, or in this case, the authors, musicians, coders, and filmmakers who laid the golden eggs that are key to the present and future value of generative AI output. I thank you and look forward to your questions.
Thank you very much. Next up is Professor Bhamati Viswanathan. Did I get that right, Professor? Am I
Perfect.
close? Okay.
Perfect.
Professor Viswanathan is a professor of law at New England Law School, and she's an expert in AI and copyright. Thank you for being here. The floor is yours, Professor.
Chairman Hawley, Senior Ranking Member Durbin, and members of this subcommittee, thank you so much. I'm honored to testify today on a subject that I feel passionate about. I feel that Senator Hawley did an excellent job of laying the table for us. I'd like to drill down on what he's presented us with so far and help us walk through this. So first, it's an interesting moment that we're at. Generative AI is a promising set of technologies, and I think we can all agree that they're beneficial. However, the training that they're engaging in is deeply problematic and troubling, and courts don't know what to do about this yet. They haven't reached a consensus on what should obviously be done about the training of AI on pirated works. So I'd like to give us a call for action and a solution as I talk us through this. First, we know that what pirate websites are doing is illegal. How do we know that? Multiple actions have been brought against pirate sites, and in every case, the pirate websites or repositories have lost. The FBI, the Department of Homeland Security, have gone after pirate websites and tried to shut them down. Now, of course, we all know this can be like whack-a-mole, right? What they shut down, they come back up again. But the point is, it's well established that what they're doing is illegal. And that makes sense. If you and I stole books from the library or from a bookstore and said, I need to train, I need to learn, I need to develop my mind, we wouldn't argue that this is fair use. We'd say, you can't steal the materials even for a good cause. That's not even what's happening here. The AI generative companies are going to pirate websites, stealing the materials that have already been stolen. It's a crime compounding a crime. How is this fair? Say you want to go drag racing, an illegal activity. I tell you, hey, there's a shop down the street that sells stolen cars for cheap. Go buy a car and you can drag race. You go, great, that helps me be able to afford what I want to do. You buy a stolen car, you drag race, you win. Do you now get to say, hey, it's okay that I bought that stolen car? It's okay that I engaged in an illegal activity. Neither activity is legal, and one is compounding the other. And that's what's happening here. It's simple. It's a crime compounding a crime. And it's not a victimless crime. As Professor Smith showed us, there are real victims here. The loss of authors' livelihoods. Mr. Baldacci will be eloquent on this topic, but as an author myself, I feel the same. The loss of my livelihood not only hurts, but it affects what I've spent my life training to do. It contravenes copyright law's basic incentive structure. I don't just teach copyright, I teach constitutional law as well. This is enshrined in the United States Constitution. The intellectual property clause is one of the things that makes this country not just great, but robust, powerful, economically hugely successful. Over $1 trillion in revenues from the creative content industries. This is truly at risk right now, this entire incentive structure that was brilliantly thought of by our founders. It has negative incentives. If you know that you can go to a pirate website and steal things, why would you ever pay for anything again? The generative AI companies have shown us the way to massive theft, not just by themselves, but by others as well. It depreciates the quality and the quantity of works out there. The trade-off of copyright law is you, the copyright author, take the risk, and the market rewards you with rewards if the marketplace likes what you've done. There is no incentive structure anymore that's been undermined by what's happening now. And there's a solution. The solution is licensing. It already exists. The licensing of works, the fair compensation of creators. These are all things that actually exist now. We don't even need new legislation in some ways. We might want that as well someday, but right now we have a solution. Enforce good, standard, accepted, acknowledged licensing practices. None of this is to say that we're against innovation. We all believe in innovation. We believe that generative AI has potential. But you cannot compromise the livelihood of creators. You cannot compromise our trove of creative activity and our entire world of art and culture and the things that we have done that make us most human and that enrich us the most. You cannot compromise those simply by saying we need new technologies to flourish. What we need is for new technologies to flourish fairly, sustainably, in ways that make sense to us and that have already been provided for by our Constitution, by the U.S. copyright law, by intellectual property law itself. It is critical that Congress recognize that this is the trade-off that matters for the livelihoods of everyone whose lives right now and well-being are at risk. Thank you so much.
Thank you very much, Professor. Next is Mr. David Baldacci. Mr. Baldacci is one of the best-selling authors in America. I don't know how many books he's had as a #1 New York Times bestseller. I bet he knows. Maybe he'll tell us. I know I've read his books. I'm delighted to have him here today. He's going to tell us about AI's impact on authors. Welcome, Mr. Baldacci.
Thank you. It's a lot. #1 bestseller. I'll leave it at that. Chairman Hawley, Ranking Member Durbin, members of the subcommittee. 119 years ago, Mark Twain traveled to D.C. and appeared before a congressional committee to advocate on behalf of stronger copyright laws. He was the most pirated author of his day. I'm pirated all over the world as well. I get why that upset him. He thought creative arts was the lifeblood of this country, and I agree with him. That was the first time at that hearing that he wore his signature white suit publicly. And he did so because he thought it represented purity of thought and spirit. I don't own a white suit. And even if I did, I don't think my wife would have let me wear it today. So you just get blue. Twain once said that travel is fatal to prejudice, meaning if you meet people where they live, you find out they're just like you. I had no chance to leave the segregated world of Richmond, Virginia when I was growing up, but I visited the library every week, and I liked to think through books. I traveled the world without a plane ticket or a passport. And born from my love of reading came my desire to be a writer. I worked away for decades and getting rejected over and over, but I kept going, honing my craft, remaining disciplined, taking the rejections head on, and using them as motivation, and finally I was successful. And after 60 novels under my belt, I worked just as hard as I ever have. It's the American way. You work hard, you play fair, you stay the course, and you'll make it. I truly believed that until my son asked ChatGPT to write a plot that read like a David Baldacci novel. In about 5 seconds, 3 pages came up that had elements of pretty much every book I'd ever written, including plot lines, twists, character names, narrative, the works. That's when I found out that the AI community had taken most of my novels without permission and fed them into their machine learning system. I truly felt like someone had backed up a truck to my imagination and stolen everything I'd ever created. I'm aware of the argument that what AI did to me and other writers is no different than an aspiring writer reading other books and learning how to use them in original ways. I can tell you from personal experience that is flatly wrong. I was once such an aspiring writer. My favorite novelist in college was John Irving. I read everything that Irving wrote. None of my novels read remotely like a John Irving novel. Why? Well, unlike AI, I can't remember every line that Irving wrote, every detail about his characters and his plots. The fact is, also unlike AI, I read other writers not to copy them or steal from them, but because I love their stories. I appreciate their talent. It's motivated me to up my game. What AI does is take what writers produce as an incredibly valuable shortcut. It's like super fuel to teach software programs what they need to know. And I have learned that these trillion-dollar companies didn't even buy my books. They got them off a website that has pirated works. They complained that it would be far too difficult to license the works from individual creators, so apparently it was more efficient to steal it. Trillion-dollar companies with battalions of lawyers did not have the resources to do things lawfully. I was once a trial lawyer. If I had made that argument in court, I would either have been laughed out of the courtroom or held in contempt by the judge, and rightly so. If AI companies only needed words, they could have fed every dictionary in the world into their machine learning. But that was not nearly good enough because it would mean decades of additional work and hundreds of billions of dollars of additional investment. What they needed was complete, well-crafted, living, breathing stories with characters that seemed real, plots that made sense, dialogue that appeared genuine, humanity on the page. And some, they needed us and our craft that we learned with the sweat of our brows and the flexing of our imaginations. And these companies have swooped in, stolen that labor in order to make enormous profits. But we, the writers, the true source of all of this, will receive nothing. AI will allow anyone, with no effort at all, to order up a novel written in the vein of an established writer. And that book can be sold saying that it reads just like a David Baldacci novel. Yes, It does read like my novels because it is my novel. It is my imagination. People complain about cheap imported goods hurting American workers. Well, we have cheap books being created by American technology flooding the market. That will mean lower profits for publishers and less money to spend on new emerging writers. Trust me, that hurts all of us. Online vendors now require the author to disclose if a book was not human created. It's getting to the point where they will have to limit the number of books that someone can publish on a weekly or even daily basis. This is insane. Source code and elements of algorithms are also protected by copyright. I would hazard to bet that if I stole any of the AI community's source codes or algorithms and then tried to profit off them, they would unleash a tsunami of lawsuits against me. However, if, as AI contends, fair use is actually my entire body of work, there is no more copyright protection for anyone. I'm sure AI believes that their IP should be fully protected against interlopers, and I agree with them. Thus, I am deeply disappointed they don't feel the same about people like me. The AI community apparently believes they are entitled to steal our work product, despite it being copyrighted, because what they are doing is so transformational. Well, let me tell you, billions of people have been transformed by books. Many significant events in human history and in this country had seminal authors and their works that rode at the head of the pack. We didn't truly emerge from the dark ages until the invention of the printing press, when books became widely available. Books also teach empathy, making the world a kinder, gentler, more meaningful place. I'm only one man, but books transform my life, propelling me to a far better existence. I am sure there are aspects of AI that will also transform the world. But if you want to bet on which side is more transformational for all of us, I will bet on books every single time. Thank you.
Thank you very much, Mr. Baldacci. Very well said. Next up and finally is Professor Edward Lee. Professor Lee is professor of law at Santa Clara University School of Law, where he has written extensively about the intersection of AI and copyright law. Thank you for being here, Professor Lee.
Chair Hawley, Ranking Member Durbin, and other members of the subcommittee. Thank you for this opportunity to testify. I'm a professor of law at Santa Clara University School of Law. I'm also a book author and a photographer, and my personal experience informs my scholarship and understanding of the importance of copyright to authors and artists across the country. In my testimony, I will discuss whether using copyrighted works to train AI models is a fair use, giving particular attention to the two recent decisions by Judges Alsop and Chabria in cases filed by book authors against Anthropic and Meta. This novel question of law, which has important implications for U.S. national interest, has sparked sharp disagreements among parties, stakeholders, and now federal judges. As Judge Bibas noted in an earlier non-generative AI case, this question of law is difficult. In my opening remarks, I would like to stress 3 points. First, I believe Judges Alsop and Chabria correctly concluded that the use of copies of works to train an AI model serves a highly transformative purpose in developing a new technology under Factor 1 of fair use. During training, an AI model is exposed to vast training materials, typically many millions of works. Through a process called deep learning, the model identifies the statistical relationships among words and within subparts of words, thereby enabling the model to conduct numerous functions, including research, translation, delivery of medical advice, generation of content, and so forth. As Judge Chabria concluded in his opinion, quote unquote, the purpose of Meta's copying was to train its large language models, which are innovative tools that can be used to generate diverse texts and perform a wide range of functions. And as Judge Alsop recognized, the technology at issue was among the most transformative many of us will see in our lifetimes. Now, the history of AI development strongly supports this conclusion. It is important to understand why AI researchers at universities began training AI models on large data sets. This practice originated not at AI companies, not at big tech, but at universities where AI researchers discovered a key insight. Scaling or using larger and more diverse data sets actually worked in developing and improving AI models, an achievement that escaped researchers for many years. This seminal breakthrough, which took decades to figure out, has propelled the advances of AI that we are witnessing today. Second, while I agree with the ultimate findings of fair use in both cases, it's important to remember that fair use is fact-specific and decided on a case-by-case basis. In some cases, a transformative purpose in AI training might be outweighed by the other factors. For example, an AI model that routinely produces outputs that are infringing, such as regurgitations, might not be a fair use even in the training of the model due to insufficient guardrails on the model. Critically, in the cases against Anthropic and Meta, the judges concluded the plaintiffs did not show the models had produced any infringing outputs of the plaintiff's works. And that can be appealed, but that is the findings of both judges. My final point is the need for caution. Caution by the courts, caution by Congress, and the states. I believe it's important to weigh the United States' interest in AI innovation. President Trump has issued an executive order making U.S. development and global leadership in AI a national priority. China has its own priority and a plan of surpassing the United States and becoming the world leader in AI by 2030. The United States' national priority in AI counsels caution. Indeed, in Google versus Oracle, another technology fair use case of national importance, the United States Supreme Court itself cautioned, quote unquote, given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the parties' dispute. Judges Alsop and Chabria departed from this approach in some controversial parts of their opinions that were just dicta. I disagree with Judge Alsop's suggestion on pirated books and Judge Chabria's suggestion on copyright dilution, as more fully elaborated in my written statement. At this juncture, I think the best approach is for Congress to wait and see how other district courts, the courts of appeals, and potentially the United States Supreme Court resolves these difficult issues, including access to pirated shadow libraries, in the many pending copyright lawsuits across the country. Thank you, Senator.
Thank you very much, Professor. Thanks for being here. Thanks again to all of our witnesses. We're going to now have 7-minute rounds of questioning, and we'll see if we can fit in maybe a couple of rounds, just depending on the time that we have. I'll start, and then we'll go to the ranking member and any other members who arrive in that time. Professor Viswanathan, let me just start with you, if I could, and let's see if we can just drill down on some of the specifics here. Mr. Baldacci mentioned in his opening statement that AI could just feed dictionaries into their platforms in order to train them. They don't do that. They prefer published works, fully formed works. Why is that? Can you give us an insight into that?
That's absolutely right. They learn syntax, structure. They learn how we learn language, right? When you learn language, you just don't learn words. You don't memorize words. You don't memorize notes when you learn music. You learn structure and syntax. And the point that Professor Lee is making is correct. They need large data sets. More is better to learn predictive language models. However, more is not everything. It's not pirated works.
So let me just ask this. You said that they are not buying the books. They're not buying Mr. Baldacci's book or anybody's book who's sitting up here, anybody in the audience. They're getting them, they're stealing them, they're pirating them from somewhere. Where are they, if they're not buying the books, they're not stealing them out of libraries, where are they getting them?
These large repositories of materials that are available online, there are many. Some are licit, some are not licit. The pirate websites in particular are not licit. So if you need a lot of material, you go out and you scoop up all that material that you can find. But you don't go to pirate websites to get that material if what you want to do is legal. None of these works are licensed. None of these works are licensed. No author has been compensated to date.
So how do they go to these, let's call them shadow libraries, to get the works illegally? They've already, by the time they go to the shadow library, the works there are already stolen, right? They've already stolen Mr. Baldacci's book, Professor Lee's book, everybody's book, your books. They've stolen them. How do they actually, when they go to the shadow library, how do they get them? I mean, how does the AI company then take possession of the particular work? Like, how
There's
does
a
that work?
process called torrenting, and I will not trouble you all with the details of torrenting, but essentially, huge amounts of data stream to you, and you get them. At the same time, you can send them out. That's called seeding. You can send them out at the same time. Uploading and downloading exist at the same time. This is a peer-to-peer process. So not only are you taking in these pirated materials, you are also distributing them. The violation of copyright law exists at the reproduction of these works, at the making available of them by the pirate libraries, the dissemination of them, and your dissemination, Gen AI company, of them as well.
So they're both taking the works and distributing them as well in this thing you call, kind of like Napster, this thing that you call torrenting. Let me ask you this. I mean, is torrenting legal? It's not legal, is it?
Torrenting can be illegal, but in this case it is not. And in this particular case, this is benefiting now, I agree with Judge Alsup, who said, if you're taking it from pirate libraries, no way. That is not acceptable, right? Part of what we're seeing here, Judge Chabria said, well, it's not helping the pirate websites. Well, yes, it is. The pirate websites, there's one in particular called Anna's Archive. They actually put on their website, hey, Gen AI companies, come train on us. We'll do some data swaps, or you know what? You can make us a donation too. This is directly helping the pirate websites thrive, flourish, proliferate.
Let me ask you this. Have there been any, to your knowledge, any criminal enforcements against these torrenting platforms?
Yes, there have been attempts to. Again, it's like a game of whack-a-mole. You get one, you knock it down, it pops up again in some jurisdiction that you don't have control over.
What's the key to a criminal enforcement? You know, civil versus criminal in this context, when do we have a criminal case against torrenting? What's the key to that?
Okay, this is a really important point. What's criminal here? Criminal copyright liability has two prongs to it. Prong one is you have to do it willfully, and prong two is you have to do it for commercial advantage or gain. We clearly know that prong two is met. This is for commercial advantage or gain. I don't think Meta is doing this out of the goodness of its heart. Prong one, willful, means you need to know that what you were doing is illegal. There's lots and lots of evidence now, particularly from the Cadre v. Meta case, that shows that they knew this was illegal. They even had to ask all the way up the chain of command to Mark Zuckerberg and say, hey, is this okay? And he said, yes, it did. Yes, it's okay. So not only did he do it knowing it was illegal, he did it knowingly, he did it willfully, intentionally, and whether or not he knew what statute it was illegal doesn't matter. For this to be willful, you have to know that what you're doing is wrong, and this meets that prong. So this is, in fact, amounting to what you might call criminal copyright liability.
Mr. Pratt, let me just ask you about this, about the willful aspect. And let's talk about Meta in particular, since Professor Viswanathan just mentioned Meta. They're one of the biggest monopolists in the world, and one of the biggest AI companies now in the world, if not the biggest. So let's just talk about them for a second. Meta uses torrents to acquire pirated data for its Llama model. Is that right?
Correct.
How much data would you estimate that Meta has torrented? It's illegally downloaded and also then shared in this peer-to-peer scheme.
It has pirated well over 200 terabytes of copyrighted material from multiple, I don't call them shadow libraries because they're not libraries, but illicit criminal enterprises.
And how much has it paid the copyright holders for these works that it's used, to your knowledge?
Nothing.
If nothing, zero. So billions of works, billions of books like Mr. Baldacci's, zero payment. If Meta were to pay, do you have any idea what the cost might be? I mean, did they ever, to your knowledge, in your discovery, did they ever explore paying? I mean, is there any sense of how much this might have cost them?
Early on, they explored licensing. They assigned 2 individuals part-time to attempt to license, and they decided it would take too long, for example, and that's when they turned to piracy. At the time, they had public documents show that certainly tens of millions, if not hundreds of millions, had been contemplated for licensing at that time.
Okay, so let's just think about this. Hundreds of millions of dollars, that's the value, maybe sort of the base, the bare value of the works that they've used, like the works that you all have written on this panel, hundreds of millions, and they paid zero of that. So let's just drill down a little further. Did Meta know what they were doing was wrong? Do you, Mr. Pritt, believe in the evidence you've seen that there's any evidence to suggest that Meta's employees knew what they were doing is illegal?
I think the documents that have become public clearly show that.
Let's just look at a few of these documents. I'm going to show you a few things, and I'll ask you to help me interpret them to make sure that we get them right. Let's start here with a Meta employee, a Meta engineer working on their AI project, Eleonora Prasani. She says, I don't think we should use pirated material. This is in a chat with other Meta employees. I don't think we should use pirated material. I really need to draw a line there. She goes on, I feel that using pirated material should be beyond our ethical threshold. Sci-Hub, ResearchGate, LibGen are basically like Pirate Bay or something like that. They are distributing content that is protected by copyright, and they're infringing it. How do you read this, Mr. Pritt? Does this look like knowledge to you?
That's certainly what we've argued in the case.
Let's look at another Meta employee. Here is Nisha Deo in the same chat. She replies and said, it's the piracy and us knowing and being accomplices that's the issue. This is a Meta engineer working on their AI project. It's the piracy and us being knowing accomplices that's the issue. Let's look at another one. Here is the response that another Meta engineer in the same chat gave. Well, we want to buy books and be nice, open people here, but, however, to make it happen and not letting the bad guys win, that's the beat China argument, we need to make a case fast and cut some corners here and there. We need to cut some corners here and there. Mr. Pritt, what are we looking at here? I mean, is this knowledge of illegal activity?
When they refer to bad guys, I think they're actually referring to OpenAI and other AI competitors. But yes, this is certainly one of the many documents that show that they knew these were pirated websites that contained copyrighted materials, and they were taking them for free.
So here we have it in black and white. Don't believe me. Read the evidence. These are Meta's own engineers, Meta's own employees saying they know what they're doing is ethically wrong, illegal, likely to subject them to legal liability, and they're doing it anyway because they need the money. There's a lot more here. We'll come back to this. I want to give Senator Durbin a chance to ask questions. Senator Durbin.
Thanks, Mr. Chairman. I want to ask startup questions with Mr. Baldacci. A number of authors have shared with the public the process they go through to write a book. I believe John Irving and My Imaginary Girlfriend did that. I think John McPhee has done that in the past. Stephen King has done that. Give us a kind of an insight, now that you have published successfully in volume, what the process is in writing a novel.
Well, you know, one, you have to sort of be in love with words and storytelling, because that's sort of the essence of what you're trying to create. You draw upon personal experiences, your own curiosities, people you've met along the way, things that have happened to you, places you've traveled to, humanistic experiences that a software platform really can't replicate. And if it ever manages to do it, I would like another planet to live on, quite frankly. And for me, it was 20 years of hard work, learning the craft before I ever was published at all. I started writing short stories and wrote them for 15 years when I was in college and law school, and tried to get them published and was not successful. But it's a craft that you build over time. And you have a lot of frustration, a lot of dips and valleys. Good times happen, bad times happen, rejections happen. You learn from them, you keep going. And at the end of the day, hopefully you get good enough to where someone who has the ability to make your career happen will read your material and respond to it, and you can then maybe hopefully write for a living. And that's what happened to me after a long period of incubation. You never really see a lot of young writers. You know, you're not going to see a lot of teenage writers making it big, because writing is about life, and you have to have something to sort of write about, and it takes a long time. And that's why I felt when my son brought this up, where every single one of my books was presented to me in an outline in like 3 seconds, it really felt like I had been robbed of everything, my entire adult life that I had worked on. Now I was in the possession of someone else that someone else I didn't even know could then use to write their own books that are actually my books. I mean, that's not supposed to happen in this country. And that's what was so enraging to me, that I license my work all over the world. I license it for different foreign publishers. I license my work for television and movies and all types of endeavors. And I'm open to any offer. If someone comes to me and wants to license my work, I will listen to them. If we can negotiate something that's agreeable to both parties, I will do it. They can use my work for the parameters that are in the licensing agreement, and life can go on and people can be happy. But the uncertainty of like stealing stuff from pirated sites operated in Russia, just so you can gain an advantage, and you don't really care about what happens to the likes of me and other writers coming up. I make a lot of money from my publisher, and my publisher has used that money to take risks on new writers coming up. They ordinarily would not have been able to take a risk on. So when you hurt established writers like me, you hurt all the other writers coming behind us.
So when you're in the process, the creative process of writing novels and other things, are you policing against plagiarism?
I'm pirated a lot, but I never worry about that because my ideas are my ideas, and nobody has the sort of mindset and the experiences that I have, nor do I have the mindset and experiences of other people. It's very individualized. I never worry about that I'm going to inadvertently take something away from another writer because my stories are my own. And that's why a software platform, the only thing they can do is take from what has already been created. They can't create anything really on their own. They take my mishmash and put it all together and throw it out the other end, but it still looks like my stuff because it is my stuff.
Professor Lee, if I understand part of your argument here, you were suggesting that this is the age of innovation. Deep learning it deserves special treatment. We've been through this argument in Congress before. Section 230 is a good illustration of that. We decided this fledgling industry called the internet just may not have a future. Better be careful. So we exempted them from liability. Is that what you're suggesting?
Not at all, Senator. My position is that we should pay heed to the existing Supreme Court precedents on fair use, which repeatedly states that fair use is a flexible doctrine decided on a case-by-case manner, and there is a way for authors to prove market harm based on a taking or the copying of protected elements of their works. Judge Alsop said, if the authors show that there is market harm based on an output of this model, you could bring another case. And that's exactly, I think, the approach to strike the correct, as you mentioned earlier, the opening remarks, to strike the right balance between protecting copyrighted works and authors and protecting innovation. Even Justice Story in Emerson versus Davies recognized that not everything in a book is protected by copyright. Authors build on the past books to write new books, and that fuels creation. And here, the line that Judge Chabria and Alsop drew in terms of non-infringing output, or excuse me, Judge Alsop, there is no copyright claim in the production of non-infringing works.
I'm sorry to interrupt you, but I only have a minute left. It looks to me like you're shifting the burden to the author of the creative work when there's an assertion of fair use here. So Meta or others can virtually steal this creative product of Mr. Baldacci and others, and then he has the responsibility of proving that there's been an economic loss to him as a result of it?
Not at all, Senator. The judges explained in their opinions that yes, the initial burden for fair use is on the defendant, but the defendants in both cases provided evidence that there was no output of infringing works. And the question then becomes, will the plaintiffs present contrary evidence? And neither judge found evidence of outputs that had substantially similar copies of the plaintiff's works. So the entire...
Ultimately, the thievery, if you want to use that word, of the creative work is for the economic benefit of those who are creating the AI, is it not?
Not necessarily. I think if the plaintiffs are able to prove cognizable market harm from the copying of their copyrighted expression, then the fair use argument is likely to fail for the training.
I'm coming at it from a different angle. I'm talking to you about why do we have AI? Why are we interested in AI? Clearly, it's a commercial purpose, is it not?
Oh, entirely. For the AI companies, yes.
For the companies, so that they are ultimately the winners in this approach that you're taking. We assume we're in the world of new innovation here, and there is a use of someone else's creative work. The burden's on them to prove that they've lost money because of that piracy. But the ultimate winner in this is going to be the AI, because if they escape this responsibility, they can use Mr. Baldacci's product and make money off of it.
Yes, if the training is considered a fair use, the direct benefit would be to the AI companies. I grant that. But in terms of the larger national interest, it redounds to the benefit of the United States. If we have a priority in AI development, and if we are in a competition or arms race with China, winning the AI race by United States companies benefits the United States, in my view.
And Mr. Baldacci should be prepared to pay the price for that, right?
Well, I would suggest that if it is so easy to generate copies of Mr. Baldacci's novels or any other authors, that should go in the complaint in these lawsuits. And some of the lawsuits do allege infringing outputs. So those are yet to be resolved. But my ultimate position is that we should not throw out the window the established Supreme Court precedents on how to apply fair use. It is case by case, flexible, and it balances the interests of both sides in terms of copyright as well as innovation.
Thank you.
I just want to follow up on this line of questioning, Professor Lee. When you say that it would be to the benefit of the United States, isn't Mr. Baldacci a citizen of the United States?
Entirely. I'm not saying that Mr. Baldacci does not benefit from the copyright. There is an
but let's take a different author. Professor Viswanathan, she's a citizen of the United States?
Yes.
So I'm just struggling to understand, when you say that it will benefit, that the mass theft of their works will benefit the United States ultimately, you're saying that the mass theft and potential impoverishment of American citizens ultimately redounds to the good of America?
Not at all, Senator.
I think you're being a little too imprecise, right? What you mean to say is it may benefit American corporations. It may impoverish American citizens, but it will benefit American corporations.
Well, Senator, there is a balance to be struck, and the courts...
Well, indeed, but it's, you are waving the wand, the magic wand of this will benefit the United States, so we're in an arms race with China. I'm just trying to drill down on your assertion. I think what you're really saying is that the enrichment of certain multinational corporations that are incidentally based in the United States, taking the works and personal property of American citizens, is a good thing. That's a little bit less clear to me.
Well, the way that I view the national interest, as stated by President Trump's executive order, is that there is a national priority in maintaining the United States' dominance and leadership globally in AI. And I would defer to the view of the AI czar, David Sachs, who said, if there is no pathway to fair use in AI training, we will lose the race with China.
Well, you think that we should allow an unelected AI czar to decide what the rights of American citizens are?
No, not at all. This is going through the courts. I would let the courts decide all of these disputes, and there are presently 44 lawsuits around the country. So this is not a time for Congress to intervene in terms of deciding these very difficult questions.
It just sounds strange to me to say that the United States as a nation is going to benefit from the mass violations of its citizens' rights. I thought what made us a nation was our common citizenship, the things that we agree on together, the rights that we hold in common. And your argument seems to be it's fine to violate those rights en masse if it redounds to the benefit of the nation. I think what you're really saying is to the benefit of certain people in the nation and their immediate interests. Let me ask you about something else you said, fair use.
Can I respond?
Well, just a second. I have limited time here. Fair use, you said, is a flexible doctrine. It's an equitable doctrine. And these companies aren't exactly coming to this with clean hands, are they? They're coming to claiming fair use after they've stolen Mr. Baldacci's work. They didn't take it from the library. They didn't license it. They didn't buy it. They went to a pirated illegal site and took it. And now they're coming and claiming the cover of equity. That seems kind of strange, doesn't it? Is that how equitable law works?
That is the very question, the initial acquisition, whether that was justified as fair use. And the two judges disagreed on how to treat that initial acquisition from the shadow libraries. So I think it would be incorrect for us to assume that it is necessarily a violation, and the Supreme Court in Google versus Oracle had an opportunity to discuss or require considerations of bad faith in the fair use analysis, and it rejected that opportunity and even cited Judge LaValle's very influential fair use article saying that fair use is not limited to the well-behaved.
Okay.
Now,
you're making these. We appreciate you being here, and you're making these arguments very gamely. That's helpful, I think, to have this debate. But I just want to point out that there's a lot of hand waving going on here. Every time we get down to the nub of the question, can these giant corporations take the copyrighted work of individual citizens? We get distracted with, well, it's for the good of the country. Maybe it's not so bad. We have an arms race on. There's an AI czar. I actually think I don't think it's that complicated. I think it's pretty simple. I think in America we have rights. Those rights are what protect us. These rights are being violated. And if we're going to succeed as a nation and uphold our principles as a nation, we better darn well enforce the individual rights on which the nation's founded. I mean, it's just a thought. Senator Welch, would you like to, am I catching you off guard? Yeah. Well, you're welcome to ask questions if you'd like.
Anyone, but especially a colleague senator and the chair of the committee, expression of righteous outrage and indignation with which I'm aligned. So thank you very much. Thank you, and I appreciate you calling this hearing because this is incredibly important. Senator Blackburn and I have a bill which is called the TRAIN Act, and it's trying to address this question of artistic content being used. And, we've got a celebrated author here, and it would protect you. But what I appreciate about you being here, Mr. Baldacci, is there's a lot of folks who are aspiring to be David Baldacci. There's a lot of artists aspiring to be a Taylor Swift, and it's the folks who've made it that are in a position to advocate. And it's not, I don't think, going to benefit you, but it's going to benefit artists who have so much to contribute, even though they're not yet discovered. And, this is the reality. This is where I think the chairman is really right. The AI companies need content, so they don't care where it comes from. It's just a voracious, insatiable appetite. And they're going to go into copyrighted material. And we just know that, and to suggest they won't, I think, is naive. And the question and the burden here is that is going into copyrighted material. And the artist has the right to have that copyright respected. The burden is that, how do you know they used it? That's the whole point of the TRAIN Act, where if there is copyright infringement, a reasonable assertion of that and suspicion of it is going to require disclosure on the part of the AI platform. So I wanted to ask a little bit about that. And I'll start with you, Mr. Baldacci. Do you have any suspicion that some of your works have been used to train AI systems?
I have been told, and I've been shown a database, and it's part of I'm part of a class action lawsuit against the AI community, and I think they've conceded that they've taken at least 44 of my novels and fed them into their large language models.
I mean, that's astonishing. Literally, you've got 44.
Well, at least they didn't take them all, so that was nice.
Just wait.
I know.
And So you don't know for sure, and the only way you're going to find out is hopefully through this class action litigation that you're part of.
Well, I certainly learned that when my son put in ChatGPT, that ChatGPT was intimately familiar with my entire body of work because it was able to throw out, plot lines that took from many of my novels. So someone had to feed my novels into ChatGPT, otherwise it could not have created that response.
We just can't allow that. That's just really wrong. Thank you. So we're in agreement here that we need some reforms here to protect the artist. Mr. Smith, music, it's the same situation. And, our music industry is so important. It's not, using the word industry is wrong. Music is so important. It really helps people get a sense of who they are. It helps people connect. And it's across political divisions. That's what's one of the inspiring things about the incredible contributions that musicians provide to our society. And can you just explain what the dangers are of allowing AI models to freely train off copyrighted works?
Sure, there are multiple dangers. What we've seen in the early piracy research is that Article 1, Section 8, Clause 8 is actually a really good idea. Giving artists incentives to create actually yields more creation, and when artists' incomes are lowered through piracy, they have lower incentives to create. I think we see the same thing here, both directly by participating in these pirated networks. The generative AI companies are making it easier for other people to steal. But then indirectly, they're also making it harder for licenses to be signed. Mr. Baldacci talks about signing licenses, but when you sign a license with a generative AI company, you're signing with a gun held to your head because they can say, either sign what I'm offering or I'm going to go steal it instead.
Wow.
That's trouble.
That's the adhesion contract that good lawyers like Senator Hawley still remember from law school days. No, but explain that a little bit more, because, this is where I think all of us have some real appreciation for young artists. They have a vision that there is something inside them that they can express and that it will make a difference to people who hear it or people who read it. And they start out against their parents' will most of the time, right? Because it's not an income-producing, promising career. And a lot of them don't succeed commercial success, but they actually are contributing in a local community to a sense that helps develop our culture and helps create respect for the creative process and helps create respect that there's other things than the career path that some of us up here have followed, where you can make a real contribution and a meaningful contribution. So this is the concern I have about how this AI and the grabbing it is going to make it tougher for those folks against great odds to keep at it. So maybe you could just, from your experience, talk a little bit about how it would adversely impact any chance they have of being able to pay their bills at the end of the month while they're trying to create inspirational music for the benefit of all of us.
Yeah, I deeply share that concern, Senator, and it's based on peer-reviewed academic research showing that creative output goes down when piracy is allowed to flourish. I worry that the future David Baldaccis of the world won't get through that hump, and we won't get to appreciate their creative output if we allow piracy to continue to be used to train these generative AI models.
Well, thank you. My time is just about up, but I just want to express my gratitude to each of the witnesses. I didn't have a chance to speak with you, but I think this is an extraordinarily important issue. I yield back.
Thank you, Senator Welch. Senator Durbin.
Mr. Pritt, you represent plaintiffs in a lawsuit against Meta that alleges copyright infringement of the plaintiff's author's works. Do you have any idea how much Meta as a company is valued?
It's a good question. Many trillions, I believe.
Did Meta compensate any of the copyright owners in your case for the use of their works?
No, but Meta did spend money on contributing its processing power to pirate from illicit websites and also to pay Amazon to host pirated data.
which of course did not inure to the benefit of your plaintiffs.
Certainly not.
How does the downloading and uploading of pirated copyright material impact the analysis of whether a copyright infringement could meet the mens rea requirement or willfulness necessary for criminal infringement?
I would let the professors answer that question. Certainly as to willfulness in the civil copyright context, as the documents Senator Hawley showed, I think the answer is clear that the piracy committed by Meta was knowing and intentional.
Anyone else want to comment on that? Mr. Lee? Dr. Lee?
Yeah, yes, thank you, Senator. The standard of willfulness for criminal copyright infringement requires knowledge that it is illegal to engage in that particular copying. Now, I don't want to relitigate what Judge Chabria has already ruled on, but he was given all of this evidence that was submitted by Mr. Pritt and his colleagues. He saw the comments by engineers, but he also saw comments and analysis by lawyers of Meta, advising them on whether this was permitted or not under fair use law. And Judge Chabria made a determination the crime fraud exception simply didn't apply. And I'm not privy to all of the analysis that Judge Chabria made, but I'm assuming it was based on the question not being resolved, the legal question of whether accessing or copying from a pirated website to serve a highly transformative purpose is the very question raised in the lawsuit. There is no prior precedent that has so held that it is piracy or illegal, let alone criminal infringement to do that. And that is the very question that Judge Chabria ruled on. And to assume that it is piracy is begging the question, with all due respect, it is begging the question that the courts are the appropriate determiners of. And that can be appealed, and I'm sure it will be appealed. But here the question of whether acquiring for a putative fair use purpose is unlawful, Judge Chabria ruled it was not. It was for the fair use purpose of developing the AI model. I believe that is supported by the text of Section 107.
So, Professor Viswanathan, would you like to comment on that?
I would, thank you so much. The very fact that we're talking about this kind of behavior as to whether or not it's criminal, right? The very fact that we're here talking about willful, knowing, intentional, massive scale training on pirated materials. Let's just step back for a moment from the question of whether it comes under criminal copyright infringement. Does it come under fair use at all? Is this what fair use was developed to be? Fair use, for those of you who don't take my copyright class, sorry about that. Fair use is an affirmative defense. Yes, I infringed, but I did it for a good reason, a societally beneficial reason. All right, maybe creating a world's repository of generative AI companies is that, but it doesn't seem to me that it squares with the other things that we think of as fair use. What's well-established fair use? Education, criticism, commentary, First Amendment purposes that we consider valuable and necessary and that are done in good faith. I educate in good faith. I don't want to have to clear all those copyrights to educate. Okay, great, we allow you to do that. That is not what's going on here. I don't want to relitigate the cases, Professor Lee, but Judge Chabria was clearly distressed by this, and when he raised the possibility, as you rightly say, in dicta, that market dilution might be what's happening, he's saying, look, exactly what the senator was talking about, flooding, what Mr. Baldacci was talking about, flooding the market with subpar works that substitute for the original works. This is not what fair use was intended to achieve or to facilitate. And the very fact that these companies are arguing we're in good faith, we're doing fair use purposes, to me, this shouldn't even be a defense that they're allowed to raise. But okay, they will raise it, and it will be litigated. But But boy, it just does not seem consonant with what fair use was ever meant to do.
Thank you. Thank you, Mr. Chairman.
Mr. Pritt, if I could just ask you another question or two about some of the evidence. We talked about Meta engineers saying that they realized what they were doing was crossing an ethical line, that they felt they shouldn't be doing it, but they had to cut some corners. Let me just ask you, did Meta ever try to hide what it was doing? Did it try to hide the fact that it was pirating these works?
What the documents show is that in 2024, when Meta began to use Anna's archive, it decided intentionally to not use its own servers and instead to go through Amazon Web Services in order to ensure that the seeding, the sharing of pirated works would not be traced back to Meta's own IP.
It doesn't sound to me like a company and executives that think what they're doing is above board. It sounds like a company that thinks that what they're doing is probably illegal in some manner, but they want to go on doing it anyway. Let me just show you a couple of documents, help us understand what we're seeing here. These are more Meta engineers now, again, working on AI. We've got the first one, Nikolai, who says, not sure we can use Meta's IPs to load through torrents pirate content. Ha ha. I emphasize, these are their documents. I mean, for all of Professor Lee's, and again, I appreciate Professor Lee making these arguments, but for all of Professor Lee's comments that we're not sure if it's really pirated or not, they thought so. This is Meta. Meta thought so. The next person says, the next employee, I'm curious to start looking at some samples, but I feel like we should get some clarity on what's allowed and how, smiling emoji. Nicolay again, haha, yeah, I think torrenting from a corporate laptop doesn't feel right. I mean, what are we looking at here, Mr. Pritt? I mean, is this an attempt to be above board and forthcoming and, they think everything's fine?
I think that is a very difficult conclusion to draw from these documents. And with all due respect to Professor Lee, as I am still litigating the case against Meta on behalf of a group of authors, Judge Chabria in that case specifically declined to decide whether Meta's piracy, what it has engaged in terms of the downloading, the making available, the making additional copies, and then sending those copies, over 40 terabytes of data, to other individuals, is in fact fair use. And no court, including the Supreme Court, has ever held that rank piracy is somehow fair use. And instead, the Supreme Court case law, the still law of the land, says that fair use presupposes good faith and fair dealing. I will leave it to you whether or not you think any of these documents shows good faith and fair dealing.
Let's just look at one other document and ask ourselves if this looks like good faith and fair dealing. More Meta employees, more AI engineers. Frank, can you clarify why we can't use Facebook infra internal for this again? Frank Zhang replies, we've got to avoid the risk of tracing back the seeder from a Facebook server. And he clarifies, avoid the risk of tracing back the seeder download are from Facebook servers. So here we have Meta employees saying they know they're pirating, they think it's ethically wrong, they think it's illegal, and they are actively avoiding trying to create a paper trail. They're trying to hide it. I mean, that doesn't sound like fair use to me. Does it sound like fair use to you, Professor Lee? I mean, do you think this is fair use?
I would just say I agree with Judge Chabria's approach. The distribution claim is still live in the case, and this aspect of the torrenting may well be infringement and not fair use.
I'll just say this. If this isn't infringement, Congress needs to do something. I mean, if the answer is that the biggest corporation in the world worth trillions of dollars can come take an individual author's work like Mr. Baldacci, lie about it, hide it, profit off of it, and there's nothing our law does about that, we need to change the law. And if nothing else comes out of this hearing today, I hope that's it. And I hope that this is motivation to this body that we need to be paying attention to what's going on here. Mr. Baldacci, you said you'd rather live in a different planet if there was AI that could write your books. I'm sure that will never happen. They'll never write your books. I want to live on a different planet if this can go on and it's perfectly legal. We've got to do something about this. Let me just ask you, Mr. Pritt, finally, what about Mark Zuckerberg and all of this? I mean, do we think that Zuckerberg knew about this, approved this? I mean, what's the evidence suggest?
Certainly the documents that have become public in the case explain that the decision whether or not to use Library Genesis, which is a notorious illicit marketplace, for example, for actual training as opposed to exploration, was escalated to Mark Zuckerberg.
I think the judge said something to this effect. Let's just look here if we've got it. That in fact, Zuckerberg was asked about it. There it is. In the spring of 2023, after failing to acquire licenses and following escalation up to Zuckerberg, Meta decided to just use the works acquired from a torrenting platform as training data. So they just did it anyway. They just, do it anyway. Forget it. Don't pay Mr. Baldacci. Don't pay anybody. It costs too much. A lot cheaper to take it for free and then make billions of dollars off of it. Listen, I'll just conclude with this. I want to thank all the witnesses for their testimony. And Senator Welch, if you have more questions, or Senator Durbin, I'm happy to let you ask those. For my part, I just want to say, I think that this is a moral issue as much as anything else. I think this is an issue about who we're going to be as a country. Are we going to be a country, as is written into our Constitution, where we protect the rights of our citizens? It's part of what makes us Americans. And we welcome the creative genius of people like Mr. Baldacci and the marvelous diversity of imagination and viewpoints and perspectives that has come to characterize our country. Are we going to protect that? Or are we going to allow a few mega corporations to vacuum it all up, digest it, and make billions of dollars in profits, maybe trillions, and pay nobody for it? That's not America. That's not our country. It never has been. Listen, I'm all for the free market. I'm glad Mark Zuckerberg can make his billions. That's fine, but not by running over people like Mr. Baldacci or anybody else, or any young author who's trying to get a start, or any other person, creative, non-creative, or just a working guy who puts something on Facebook. Why should all his stuff get taken? I just think that's wrong. I think it's morally wrong. I think, frankly, it's not consonant with our principles as Americans. And I think we can and should do better than that. Senator Welch, Senator Durbin? I want to thank again the witnesses for being here. Thanks to each of you. I know you had to travel far for this. And thank you for accommodating our schedule. Thanks to everyone who's been here today. And with that, we'll stand adjourned.